Hi there, my name is Tate Lounsbury with My Court Coach, and we have with us today Chris Funtal. How you doing, Chris?
Good. How you doing?
I'm doing excellent, thank you. Thank you for being here, and I want to welcome anyone who's watching our live stream. This is Tuesday night. We do our live streams with Chris Funtal on California family law issues. By way of introduction, we are with mycourtcoach.com, where you can get coaching for your family law case. My Court Coach is your resource for anyone who is in court representing themselves without a lawyer. My Court Coach has just a ton of resources for you: videos, tutorials, scripts, downloadable PDFs, guides, checklists. You name it, whatever you need, especially in family court or any court. There's the rules of evidence explained, and there's audio recordings that you can listen to while you're driving, all sorts of information there. In our live stream today, we are not going to be providing any legal advice. No legal advice here. Instead, what we're providing is some coaching. So do not rely on anything that we say to use it in your own particular case, because we're not giving any specific legal advice or strategy for you and as an individual to use. You should use this as basically entertainment value. Okay, those are all the disclaimers I can think of that we need to get off the right out of the bat. Okay, let's get started. We have some questions that we're going to be answering here from comments from our YouTube videos. If you have any questions from any YouTube videos that you've seen that we've posted, any of the My Court Coach videos, you should always have a comment on there, and then we'll bring it up in this live stream. And of course, you can ask questions here on this live stream. All right, let's get to the question. It'll take me a second here. All right, this is a question asked about this form, the FL 130 form. And the title of this form is Appearance Stipulations and Waivers. What is this form about?
This is a form you would use if the parties had reached a complete agreement, like a marital settlement agreement or something like that. You don't necessarily have to use this form. You could include some of this language inside the actual marital settlement agreement that the parties signed. But if they don't have that, sometimes the court's going to require waivers by the parties to let them know that they have the right to a hearing or a trial and that they're waiving it or something like that. From the question that she presented, it's not real clear what she's trying to do with it, but I wouldn't fill out one of these forms unless there was an agreement. Frequently, these are attached to the front of a marital settlement agreement and judgment package that you submit to the judge for processing. 90% of the cases won't ever see one of these. So it just depends on the situation.
So the question is, me as a petitioner, do I fill out the section that says appearance by respondent?
Yeah, and I don't really understand what she's asking, because there isn't a section that says that. I mean, it would be one form that would be signed by both sides, and if they have attorneys, by the attorneys on each side as well. So there's a place for all four signatures. I'm not sure if that's what she's asking, though.
Well, let me bring it up here again. This is for the FL 341, and I don't know if you see it here. The paragraph 1 says appearance by respondent.
FL 341. That's a different form.
Oh, I'm sorry. FL 130. I'm sorry.
Yeah, okay.
This is FL 130. Now, did you pull it up
Yeah, I've got it in front of me. So if the respondent hasn't filed a response to the action, you could use this form instead. Keep in mind, though, that if the respondent hasn't filed an answer to the lawsuit, then the court's going to want his first paper fee, which is $435 at this time. I mean, you might be better off coming up with an agreement and just doing it by way of a default if that's possible. Not really possible to do that if people have kids, because sooner or later, you're going to go back to court to deal with some kind of an issue when things change in the child's life. But, generally speaking, the respondent files an answer, so you wouldn't have to check any of these boxes.
And so that word appearance means, what does that mean? Is that like the respondent's first paperwork that he or she is filing with the court?
Yes. In the rules of court, unlike regular civil actions, the first appearance has to be in writing. And if the respondent never makes an appearance, then the petitioner would probably proceed via default, assuming she's got proof that he or she has proof that they served the other side. But if you're going to be paying your first paper fee anyways, you might as well just do your answer, pay your first paper fee, and then you can still proceed by way of a marital settlement agreement, resolving all issues in the case.
You mean the respondent? The respondent might as well just file it and answer.
Well, you being both parties. I mean, it takes both sides to have an agreement.
All right.
It's just that when, a year from now, when things have been going back and forth, and then it turns out that they thought they had an agreement, but they don't have an agreement, that kind of makes a mess, because then what do? You still file the default? In which case then the respondent has to file a motion to set aside the default and all that lovely stuff.
So most of the time this form isn't used.
Correct.
Yeah, okay. Okay. I think that is all the questions that we're going to answer today. And let's see.
Was there somebody that was going to log in or something? You had indicated that somebody wanted to do a live question.
Yeah, but I don't see the person here. So, so I think that is it. So this individual here who made this comment gets a video just for her.
Okay.
So thank you so much, Chris, for joining us. I hope this is helpful to anyone who's trying to figure out how to use this form and trying to figure out how to come up with the best way of getting an agreement between the petitioner and the respondent for family court. As always, if you have any questions, go ahead and join My Court Coach. You can join for free. You can check out all our resources there. And of course, we do have monthly coaching where you can join a monthly coaching program where you get regular coaching, live coaching with a real family lawyer, such as Chris Montal. If you want to find him, you can Google his name. He's a family lawyer here in Southern California. And I want to thank you, Chris, once again for all your help today.
You're welcome. Talk to you later.
All right. Have a good one. Bye-bye.